Hi there, Jonathan Ginsberg here. I'd like to talk to you about a part of the bankruptcy law that can be a little confusing, and I wanted to shed some light about how it works, and that is the concept of preferences, which is set out in Bankruptcy Code Section 547. And basically what a preference is, it's a provision of the code that says that certain payments on debts that are made to certain creditors can be reversed by the trustee because they are treating those creditors unfairly well. And specifically what I'm talking about are situations where you think about filing bankruptcy and you borrowed $10,000 from your brother 2 years ago and you haven't made any payments on it. Now you're thinking about filing bankruptcy and you empty out your bank account and pay him back, or you transfer a paid up car to him. Basically what you're doing is you're paying your brother to the exclusion of other creditors, and he's getting the benefit of that last bit of cash or equity other people would not. And big picture is that with a preference, it's typically a payment of more than $600, and it's on an old debt, kind of an old stale debt. And we'll talk about the exceptions, ordinary course of business exception, but generally it's going to be an old debt you haven't been making payments on. So if it's made to an insider, if you pay an old debt to an insider, your mother, your father, your brother, your sister, a company you own, something like that, and it's made within 1 year, 365 days of you filing bankruptcy, the trustee can go in and reverse that transfer and go to the recipient of the payment and say, you've got to pay that money back to me for the benefit of the bankruptcy estate. So again, in our example, your brother gets a letter from the trustee saying, you know that $10,000 you got to give it back. Not a very pleasant thing to have to go through. If it's to a third party, and again, this would be, it could be a mortgage company, a car lender, a credit card company, it's a 3-month look back. So, for example, if you have been harassed by a credit card and you just basically, to get them off your back, you cut them a check for $5,000 and then file bankruptcy a week later, the trustee can go to that credit card company and say, you've got to pay that money back. That was a preferential payment. Now, the one big exception to preferences, and I've already mentioned it's got to be more than $600 in a consumer case, but the one big exception is something called ordinary course of business. So if you're making your mortgage company payments on time every month, you're making your car payments, that would not be a preference. That's ordinary course of business. Paying your landlord on a rental, that's an ordinary course of business type of debt. But if it's an old debt, again, a credit card you hadn't paid on in a couple of years, or a payment to a relative that you never paid on, a lot of times there's handshake deals or never any terms, but you haven't made any payments on them for 6 months or a year, that's likely to be a preference. And obviously the trustee is going to be more concerned about payments to these insiders, people that you're close to. So again, you need to talk to your lawyer about this, but anytime you make kind of big lump sum payments to anybody right before filing a bankruptcy, that is a problem. And I think in general, any sort of major financial move that you might make prior to filing bankruptcy, don't do it unless you talk to your lawyer, because usually it doesn't pass the smell test, and kind of common sense would tell you that you can't, trade your car to your brother for $100, or you can't pay a debt back to somebody just to protect that person, not everybody else. Bankruptcy is kind of about fairness and treating all creditors the same within of a certain type of class. Unsecured creditors treated a certain way, secured creditors a certain way, that sort of thing. So again, talk to your lawyer, but if you've made any big payments to anybody recently when you're thinking about filing bankruptcy, it's definitely something you want to discuss with your attorney. Again, I'm Jonathan Ginsberg. I'm an Atlanta bankruptcy attorney. Any questions about this or anything else about bankruptcy, I want you to feel free to give me a call. Thanks a lot.